All rise. We will be. Please be seated. Viva Suswa.
Welcome back again to all parties and participants. I presume that the appearance remained the same.
Your Honour, we have one extra person in our team, Miss Kirsty Sutherland, a young lawyer from my chambers who's working on the case.
Thank you very much.
And, Your Honour, we too have an addition, Miss Alison Schwall.
Thank you.
Nobody extra from our side. Thank you, Madam President.
Thank you very much. Before going back to the discussion, as a preliminary matter, the Chamber would like to announce that it intends to convene a status conference on 13th February to be devoted to the pending Article 87.7 application, subject to availability of parties and participants. So this is a tentative decision of the Chamber, and the formal scheduling order will be issued very soon.
Madam President, could I
Yes.
clarify, as you know, I'm living in Kenya in accordance with the order of the Child Chamber. Is it your desire to have me attending that status conference? I certainly would be more than happy to do so, given that it does impact on the progress of this case.
That's the intention of the Chamber.
Thank you, Madam President.
Thank you.
Madam President, may I mention one matter about that date? I'm actually booked for judicial sittings that week in England as part of my duties as a recorder of the Crown Court. And I'm booked for a week sitting in court as a judge myself. So I'd be grateful, because of the difficulties involved in rearranging such sittings, if we could choose perhaps a date on the following week.
Thank you very much. The Chamber will communicate with all parties and participants through email and find a suitable date and place. Well, the intention of the Chamber is that we just temporarily or tentatively announce its intention, and this is it is in light of that the Chamber has requested that the submissions today do not unnecessarily enter into the merits of the Article 87.7 application, although the Chamber is fully aware of the difficulty of drawing a line, clear line between two issues. Well, especially considering the contents of the most recent prosecution filing. Having said this, I'd now like to invite prosecution to respond to the discussion we had in the morning, and then I'll give the floor to the defense. Prosecution, please.
Thank you, Madam President. It may be worth
Sorry, please proceed.
Not at all. It may be worth my reminding all the participants, and indeed those following in the public gallery, the question which Your Honours wished me to answer. And reading from the transcript, I have it thus. In the light of the admission that you do not at this stage have sufficient evidence to meet the required standard, and that you're not sure whether you can get sufficient evidence even if the government of Kenya will comply with your request, on what legal basis do you consider it appropriate to seek a continuation of the proceedings, in particular with regard to the provisions of Regulation 60 of the Office of the Prosecutor? Your Honours, it's worth bearing in mind that it has always been a central part of the case advanced by the prosecution that the accused financed, at least in part, the violence which followed the election in Kenya. It was with that in mind that nearly 2 years ago the prosecution sought the information about his financial records with the intention of gaining evidence which went to a central contention in the case. Looking at Regulation 60, it can, I hope fairly, be summarised thus. If the prosecution considers that the evidence available does not support the charges, then it must withdraw those charges. Those are the relevant parts of it to which I'm sure your question is directed. The prosecution submits that the evidence about Mr. Kenyatta's financial transactions at the time of the post-election violence plainly is available. That has not been denied by the Kenyan government. They haven't refused to cooperate on the basis that this material simply doesn't exist, nor has it been suggested by Mr. Kenyatta himself. So the evidence is available. Unfortunately, it has been withheld from the prosecution through what the prosecution characterised as the deliberate obstruction of the Kenyan government, of which the accused person is the head. And therefore, the prosecution has not been in the position to make the consideration which is at the heart of Regulation 60. The prosecution cannot consider whether or not that available but withheld evidence supports the charges sufficiently for the trial to continue, because of the obstruction of which I have spoken. And therefore, the consequence, when we have made that consideration, if it does not support the charges, the consequence of withdrawal simply doesn't arise yet. We need to be in a position to consider that evidence, and we are not. Can I assist the Court in any other way on that point?
Thank you very much. Now I would like to give the floor to the defense.
Thank you, Your Honour. Taking up the last point, in our submission, Regulation 60 plainly refers to the evidence available to the prosecution and the evidence that they have to bring a case is the matter that is the subject of that particular regulation. Otherwise, it becomes fanciful law. There may be anything available that they can't get, and anything may be able to become available that they can't get, and that would enable them to continue with any case, notwithstanding the fact they didn't have the evidence available to themselves. We've reached the stage today where issues are to be considered as to how we got here. Listening to Mr. Gaynor this morning, giving his statements to the court and to the public about the state of the case, bore no relation to the evidence in the case. And that is precisely why we have a justice system and a court of law. People are tried on evidence, not statements that are made in the media, not statements that are passed around that become the narrative, and the narrative is designed to become the case. It is the evidence that brings a trial to a court, and it is the evidence that has to be considered. We have a structure at this court called the confirmation of charges, and the confirmation of charges hearing determines the charges and identifies the evidence upon which a trial will be based. The important issue that has taken place in this case is that the evidence upon which the confirmation of charges was based has subsequently been found to have been false. Statements made by witness 4 and witness number 12 were lies. So the case that Mr. Gaynor talks about is a case and an accusation that was based upon falsity. False stories are meant to be wheedled out, filtered out by court proceedings, because experience has shown that courts require to consider allegations and to check the reliability of the evidence upon which the accuser is making his allegations. This case had a confirmation of charges hearing in which the prosecutor was able not to call witnesses, was able to summarize evidence, and was able to put a short form of the case to prevent inspection at the confirmation of charges stage. And it was made quite clear by Her Honour Judge Trendifilova in the pre-trial chamber that that was to be the structure of these proceedings. The defence, who at that time contested heavily the proceedings, were also limited in the ability to produce exonerating evidence. The accounts of witnesses 4 and 12, which were the central points of the prosecution's allegation that there was a common plan in relation to the post-election violence, was considered by the pre-trial chamber, and its decision based upon their statements and their evidence. The defence, in challenging right from the start the quality of that evidence, the reliability, the fact of inconsistent statements, the fact of changing statements, the fact of its inaccuracy, as well as the denial by witnesses alleged to have been part of that, produced before the court in statement form because we were only limited to 2 witnesses. We couldn't call the 10 witnesses we wanted to call. We actually have been the parties, or the party, it was parties involving all defendants at the beginning, that have been seeking the truth in this case. It is us who alerted the court to the falsity of this evidence and its unreliability. Extensive submissions were made by us to the judges in oral and written form, setting out the reasons why we believed this evidence was incorrect and not true. Although we were confirmed on the charges for trial, we sought leave to appeal, as we believed the wholesale rejection of all defence points by the single judge was unfair. We believed that there had only been consideration of prosecution evidence going to the alleged truth of the matter and a wholesale rejection of defence evidence. So what has happened then? What has happened was that a narrative was created. A narrative by the prosecution, first of all in its investigation filings, then in the confirmation of charges, a narrative that has been a hope that Mr. Gaynor's clients have clung to, believing that someone who was responsible should be punished. That narrative, however, with all its passion from him, was based upon false evidence. No court can permit, in such circumstances, a miscarriage of justice, that false evidence be the basis for the continuation of proceedings. That's not justice, that's a denial of justice to the party who has been accused. The problem with making public statements such as those Mr. Gaynor made today, statements made by the predecessor of the prosecutor who is in office today, was that it builds expectations that the case they have built is a true case. That fuels not only the victims, the opponents of an individual, the court, that fuels a narrative that people believe was the truth. And that's probably why Pre-Trial Chamber 2 rejected all the defence evidence and made the wrong decisions in its judgment to confirm charges. But we warned everybody. We came back to this court last year when it was revealed that witness 4 had lied. we came back and said, there is the danger of a miscarriage of justice here, that whilst there may be this narrative, it is not the truth. This case should be reconsidered because there are serious doubts about the quality of the evidence remaining. A decision was made in relation to Ambassador Muthara that he be discharged from the proceedings, but a different decision was made in relation to Mr. Kenyatta that he remain, because it was alleged there was other evidence against him. A meeting on another date provided by witness OTP 12. No one had checked the quality of that evidence and considered its reliability, except for the defence. We repeatedly alerted the court, the prosecutor, in correspondence, as to the inconsistency and the falsity of the evidence upon which they were seeking to rely. Our warnings were not heeded. In this case, the defence have made unprecedented defence disclosure. We have produced nearly 40 witness statements that the prosecution have been able to see from defence witnesses. Those supplied at the confirmation of charges hearing and subsequent ones in relation to our continued informing of them that the evidence they were seeking to bring was false and wrong and demonstrably so. We have released tapes of interviews with witnesses 152, witness 11, witness 12 to the prosecution so they could hear for themselves what they were saying when these witnesses first came to us and wanted money, but we didn't want to go down that route. And then off they went to a member of so-called civil society in Kenya who diverted them to the prosecution. Witness 4 also came through the hands of so-called civil society in Kenya. And his story that changed and grew bigger and bigger and bigger, we have no doubt was because of the influence and the hands that he was in controlling him. So this case was a case not based on truth. And that's what should be of concern to the Victims' Council today. During the last 4 years that the prosecution have had to prepare the case, they have been able to access witnesses in Kenya. They have been able to obtain documents. We have seen the vast amount of disclosure they have produced. They have been throughout the media archives. But their investigation was not an investigation for the truth. It wasn't an Article 54 investigation until, if I may say so, Mr. Gumpert arrived on the scene. He was plainly troubled by the inconsistencies within the evidence of witness OTP 12.
Mr. Kay, sorry to interrupt. I thought that you asked for the floor to respond to Mr. Gaynor.
Yes, I have.
Can you confine your statement to that point? Thanks.
It's the issue of the search for the truth, Your Honour, which Mr. Gumpert no doubt went on when he interviewed witness 12. And for Mr. Gaynor to say that there hasn't been an attempt to search for the truth is absolutely incorrect. It was that search for the truth that unhinged the evidence in this case. When it's said that there's been no cooperation from the accused has defence rights. That has to be acknowledged. And we as his counsel have every right to enforce and use those rights. When it's said we have attempted to stop the proceedings at every opportunity, well, we have, because we have known that the evidence was false, and we would have been failing in our duty to this court if we had done nothing less. Uhuru Kenyatta gave evidence at the confirmation of charges hearing. He called a witness. He has cooperated with the court. He was available to be questioned by anyone. We all have a record of that questioning and where it went and how far it got. The defence here have translated transcripts from witness OTP 12 taken by the prosecution. It was us who alerted the court and the prosecution to issues within those documents. This is proper and effective litigation, not to be criticised. This is the legitimate right of the defence to play its part in these proceedings, in the presentation of the facts and the truth. It was the defence who went on the search for phone data. It was the defence who attempted to get the phone companies to release data, and they refused. It was the defence who suggested to the prosecution the appointment of a single joint expert. It was the defence who took proceedings in Kenya to obtain the phone data from the phone companies. I invited the prosecution to join us as plaintiff, but it was declined. They provided a supportive statement, which was perfectly proper. All that evidence, in fact, goes to the truth in this case, and the prosecution are very well aware of it. Mr. Gaynor may not know this, but on the 24th of January, the single joint expert certified the authenticity of the data obtained and gives a detailed account of the fact of the impossibility of its fabrication. It's simply impossible. So stirring up emotions with unfounded allegations, misrepresentations of what has taken place during the currency of these proceedings in our submission is unhelpful. We have come to the stage where the case presented reveals that it is not a case, that it is a case with allegations based upon falsity. Prosecution know that. They know there's no contest over that matter. The problem is now, though, that having taken two sides to go on trial in a selective way, a political problem emerges. But the politics of this matter should not be a consideration for the justice of the case. That is wrong. That is unfair. Sometimes courts faced with difficult situations, tough decisions, judges know the pressures, expectations from one side against the other. Those tough decisions may disappoint people at the time they're made, but they're the right decision, because history often shows that bad decisions do not go away. And that's precisely what happened with the confirmation of charges in this case. That is why there is a lack of respect for what happened on the evidence for the prosecutor's case. That causes the difficulty. When those things happen, they are best admitted to have happened, rather than continuing and attempting to produce another allegation, false allegation, from elsewhere. It was notable in OTP 12's last interview with Mr. Gumper. That's exactly what he was doing. Oh, if you want another one, I've got one here. Quite remarkable. But anyone dealing with those people would have worked this matter out at an earlier stage. But the problem is, everyone got on board the narrative. That's how it is. For them, the evidence is an inconvenient truth. For us, it is a necessary justice. Thank you.
Thank you very much. Judge Freeman has a question to ask.
Thank you for the floor. Mr. Kay, I would like to come back to the first part of your speech you have made before the lunch break.
Yes.
Did I understood you correctly that the only obstacle which prevents government of Kenya from responding to prosecution requests on Mr. Kenyatta financial records is the fact that such a request had been submitted by prosecution itself, not through our chamber? I am aware you are currently not representing Kenya government here, but taking into account the leading position of your client within the Kenya government, I believe you can respond to my question.
Thank you, Your Honour. May I make it entirely clear, I've not been involved at all in the government of Kenya litigation. I have insisted that there is a division because there are potential conflicts of interest, and that has been acknowledged. I was looking at the argument myself for the first time upon the filing that was made by the prosecution and went back to consider it. I don't know what the rules and laws are within Kenya over particular issues. I don't know whether you've got to establish grounds for the revelation of evidence. You have to show why you want it. I know that at the Yugoslavia Tribunal, you have to give a reason and the nexus for the provision of evidence. It seemed to me from the argument that had broken out between the government of Kenya and the prosecutor that the government of Kenya was saying, we have cooperated, but you also need, if you're to use Article 93, a request from the court, so a procedural matter. As to the detail of what happens after that, I do not know, because quite clearly, I've considered the evidence in this case about the money. It makes absolutely no sense at all. £20 million cash taken out of the Kenyan banking system in a heartbeat and provided to people, and we have no evidence if this did happen from financial sources readily available to the prosecution as to how, what effect that would happen if it happened on the money markets in Kenya on a particular day at that time. Easily recognizable evidence. To us, the issue of the financial allegations were fabricated, witness 12 being the source of them. And so what is being sought to rely upon here is witness 12, who's the liar, and his connection with the money. Well, this is, as I said earlier in the day, an attempt to cling on to something that they can rely upon. If it was so important and had any truth, it could have been investigated and requested earlier. But there is simply no other evidence in it. The intriguing thing about the evidence is there's not a single person with any of this money in their hands. It's easy to talk about saying, oh, finance, cash was given. But where? I mean, who saw it? No, it does not make sense. It's not true. The whole story of the sudden production of the money on the 30th of December, like that in a heartbeat, after banking hours, and it's produced, belies the account anyway, and the need for the records. And none of the people alleged to have received this money are seen in possession of it anyway. It is a complete red herring. It's again part of the narrative. If you are a prominent person, if you are wealthy, it's an easy stone to throw. But the factual basis of it, when you look at who's making these assertions, and it is not independently corroborated, and it comes from the false sources. In our submission, our view was that this was clutching on to try and blame someone else and make them responsible for it.
Sorry to interrupt you, Mr. Kay. I think it's enough for me, because for me the main issue was the obstacle, and the substance for that maybe we will deal with in depth with that during the next status conference. So thank you very much.
Thank you.
Your Honours may feel that you've heard enough from me. There's one tiny point of detail in
Yes,
relation
please.
to something Mr. Kay said just a moment ago. it isn't right to say that allegations about the distribution of money said to have come from the accused person come only from witnesses 11 and 12. Witnesses 152, 429, 430, 510, 494, and 428 all speak about the distribution of money, which it was said at the point of distribution had come from higher up, and on occasions specifically it was said had come from Mr. Kenyatta.
Thank you very much. I think it's enough to discuss all detailed evidence about money. Thank you very much, parties and participants. The bench has two more questions to ask parties and participants. Prosecution has repeatedly argued that it is premature to discussing the issue of withdrawal of charges or termination of the proceedings. Nonetheless, the bench, for its own benefit, appreciate if parties and participants enlighten us and answer to the following two questions to the extent it is possible for them to answer at this stage. The first question is what parties and participants would consider to be the appropriate procedure for withdrawal of charges. The second question is what parties and participants consider the differences to be between a termination of proceedings and a withdrawal of charges at this stage before commencement of trial, including any differences in the legal effect of those two courses of action. I would like to start with prosecution.
Would you want to just give me a moment? Your Honours will clearly have understood that it is the prosecution's case that under the provisions of Article 61(9) of the Rome Statute, the discretion to withdraw the charges is a discretion held by the prosecutor, and that withdrawal may be made without seeking or gaining the leave of the court up until the opening of the trial, which, and this I hope is one point where there is no dispute, the opening of the trial is the making of the opening speeches, so that plainly we have reached the stage, we have not reached that stage yet. We rely upon what we submit is the clear wording of Article 61(9), which in relevant part reads as follows. After the commencement of the trial, the prosecutor may, with the permission of the trial chamber, withdraw the charges. This matter was touched upon briefly, as, Madam President, you will be well aware, at the conclusion of the proceedings against Mr. Muthaura. And the submissions made by the defence in paragraph 11 of their submission, which is document 878 rely upon the decision made, the Mathaura decision, if I may call it that in shorthand, as being authority for the contrary proposition, namely that the prosecution at this stage would require the leave, the permission of the court to withdraw the charges. The prosecution would submit that those decisions amount to no such thing. It's perhaps worth noting that the submissions of the parties at that hearing, defence and prosecution, were unanimous. Both the defence and the prosecution submitted that at this stage of proceedings, the equivalent stage of proceedings to this, no such leave was required, that it remained the sole discretion of the prosecutor as to whether the charges should or should not be withdrawn. It's instructive to look at the decision, which is document 696, and at paragraph 10. It may be that members of the court, as presently constituted, are not as familiar with that as you are, Madam President, because, of course, at that time of the currently constituted court, only you remain. And I have copies here, if it would be of assistance to the two other members of the bench, because I need to make reference to that decision in a little detail in order to answer the first of Your Honour's questions. Would that be of assistance?
Can court officer pick up those files?
Just so that Mr. Kay is aware of what I'm handing to the bench. I'm sure he doesn't suspect any impropriety, but there is a third copy for him as well, if he would like. If this is too much detail, the court will, of course, stop me. But the question which the court has asked is a matter of a little complexity, and a full and proper and, I hope, helpful answer requires some detailed reference to the authority.
Well, I appreciate if you could be as concise as possible.
I
Thank
certainly
you.
shall be, Madam President. Can I invite Your Honour's attention to page 6 of 9 of the first document before the divider, and in particular to the heading Analysis and Conclusions and paragraph 10. The court there notes that the article and sub-article from which I have just quoted does not squarely address the situation which is now before the Chamber, where charges are withdrawn after the confirmation decision, but before commencement of the trial. So we can see there that we are indeed in an exactly parallel position with regard to the charges against Mr. Kenyatta, as the court was then with regard to the charges against Mr. Mathaura. Having noted that the rules do not, as the court then put it, squarely address the situation, the court went on. In the present case, the prosecution has submitted that current evidence does not support the charges against Mr. Mathaura, that it has no reasonable prospect of securing evidence that could sustain proof beyond reasonable doubt. Significantly, the Mathaura defence does not contest the prosecution's withdrawal. In these circumstances, the Chamber, acting pursuant to Article 64(2) of the statute, considers that the withdrawal of the charges against Mr. Mathaura may be granted. That is as far as the decision of the court to which all three judges put their name goes in clarifying the situation. And I would respectfully submit that in no sense does that finding support the submission made by the defence in paragraph 11 of document 878, where they assert that the discretion to grant the withdrawal of charges against an accused following a request by the prosecution lies with the Chamber. It would be an extraordinary manner of proceeding, and one which we can be quite clear that the Chamber was not, at least in its unified judgment, the judgment which all three judges signed, going anywhere near establishing that as a proposition of law. Indeed, the court had no need to make any such radical finding, apparently in the face of the wording of the statute, because the parties were in agreement. At best, what it is, I respectfully submit, is an obiter, a parallel remark made by the court in coming to their judgment, that they may grant, even the tense, or the mood, I should say, is a conditional one. There is no positive finding that any such grant of permission or leave is necessary. So, with great respect to my learned friend, when he asserts that this decision is clear authority, that in this situation the prosecutor needs the permission of the court to withdraw the charges, it is no such thing. The court quite clearly and consciously abstains from making any finding about whether permission is necessary or not. It's fair to say that there were two judgments or opinions which were not the result of the unified findings of the court, but which were individual ones. And the first of those, of course, came from you, Madam President. And again, it may be helpful for your brother judges to go beyond the little green divider. And I apologise if this is all old hat, but it may nonetheless be helpful. And to look at page 3 of 5, which is headed, "The Partly Dissenting Opinion of Judge Ozaki." And there, Your Honour plainly states, and I'm at paragraph 2, "In my view, Article 61(9), that is the article from which I quoted at the beginning of these submissions, is lex specialis in relation to amending or withdrawing the charges in the post-confirmation phase of proceedings before the court. As noted by the majority, this provision clearly provides that after the confirmation hearing, but before the trial has begun, the prosecutor may amend the charges with the permission of the pre-trial chamber. It equally clearly provides that after the commencement of the trial, charges may be withdrawn with the permission of the trial chamber. Like the majority, I consider that the trial has not yet commenced for the purposes of Article 61(9), and you then go on to summarise what is the commencement of the trial. And I'll leave that. I go to the foot of the page. Accordingly, on a plain text reading of Article 61(9), there is no requirement for the prosecutor to seek the permission of any chamber in order to withdraw the charges in the period following confirmation and prior to the commencement of the trial proper. And I respectfully submit that that is an accurate statement of the law. If contrary, it would require, as you, Madam President, went on to point out, and I shan't read it, but I'll summarise it in a couple of sentences, it would require the Chamber to be reading into the statute a wholly unfounded limitation upon the discretion of the prosecutor. There's a much lengthier document than Your Honour's concise, partly dissenting judgment from Judge Eboe Osuji, who was then sitting on the case. It's 14 pages and some 38 paragraphs long. I can summarise it thus, and I hope I don't do violence. He effectively says that the drafters of the statute made a mistake, his word, not mine, and that what they meant to say was that at this stage, post-confirmation, the leave of the Chamber is required. Well, I respectfully accept that that was, and maybe still is, Judge Eboe Osuji's opinion on the matter. But even if it's right, if the drafters made a mistake, and if the plain language of the article is such that the only way Judge Eboe Osuji could interpret it in the way that he thought right was to state that it was a mistake, then that mistake cannot be corrected by action by the court in reading the statute contrary to its plain meaning. It must be corrected by the Assembly of State Parties, amending the statute to erase the mistake and substitute the correct meaning. In sum, therefore, the answer to Your Honour's first question, what is the appropriate procedure for the withdrawal of the charges, is that the prosecutor comes before the court and announces that exercising her discretion under Article 61(9) and in accordance with Regulation 60, she withdraws the charges. And if that occurs before the trial commences, at that point, the charges are withdrawn. Which brings me, neatly, I hope, to the difference, Your Honour's second question, the difference between termination and withdrawal. I hope that I have accurately summarised what is a withdrawal, and I shall say no more about that. As to termination, once again, we learn, I respectfully submit, by reference to Your Honour's judgment or opinion in this matter. And if you'll just give me a moment, I need to locate the precise passage. It's in paragraph 3, which is on page 4 of 5, just after the green divider. The paragraph begins, "I cannot accept the implicit premise." And it's the last sentence to which I want to draw the bench's attention. Your Honour said this, "I would therefore interpret the powers conferred on the Chamber in Articles 64(2) and 61(11) of the statute and Rule 134(1) of the rules to extend to ordering the formal discontinuance of the case and issuing any related orders, but not to authorising a withdrawal of charges which remains in the sole discretion of the prosecutor." The common law lawyers amongst us, and I apologise in that I am one of them, and therefore I'm referring to a system with which I am familiar, will be aware that at the conclusion of a trial, if the prosecution offers no evidence, there will still be ancillary orders to be made. Firstly, the verdict of not guilty will have to be entered. Secondly, there may be matters of bail or custody to be dealt with, which will require the bench, in the case of a prisoner in custody, not Mr. Kenyatta's case, of course, but it's plainly a parallel order, the discharge of the person from the custody of the court, the discharge of the accused. That, I would respectfully submit, must be what Your Honour was referring to when you were speaking of the formal discontinuance of the case. It's plain at that stage that the case could not continue because the prosecutor has exercised her sole discretion to withdraw the charges, but nonetheless the case is still before the court and orders need to be made. Of course, one fundamental difference, which it might be argued there is the question of whether or not the conclusion of the case would prevent any further proceedings against the same person. I would respectfully submit that it is plain that the discontinuance of a case, the withdrawal of the charges by the prosecutor, would not have any such consequence. Indeed, it would be disastrous if it were to. Let us imagine for a moment that Your Honours were against the submissions which I hope will persuade you, but I contemplate the possibility that they may not, and decided that there was really no alternative at this stage but for the prosecutor to withdraw the charges, and that our submissions about the trial being adjourned on the basis of non-cooperation had failed. If the prosecutor were then to withdraw the charges, it would plainly not be a bar to any subsequent proceedings which might be based upon new evidence. I say plainly because if new evidence were to emerge, let us suppose that the parallel proceedings, which are to be heard at some time in the month of February, led to a conclusion that the government of Kenya was indeed in default, and that finding having been made, the government of Kenya then complied in respect of the financial documents, perhaps in respect of a tranche of other material, which we say has not been provided when it should have been. And that material were indeed to provide grounds on which to base a prosecution. It would be fundamentally unjust and contrary to the principle of impunity on which this court is based, for there to be no such further prosecution. So those are the distinctions I would draw between withdrawal, between withdrawal and termination, and also my submissions in respect of who has the power ultimately to withdraw or permit the case to be withdrawn. Is there any other assistance I can give Your Honours on those points?
Thank you very much. May I now turn to the defense?
Thank you, Your Honour. On this issue, we looked at it and we saw the partially dissenting opinion leaving two other judges, and so we thought we were accurately stating the law as determined by them, which is why we expressed it in the way that we did in our filing. But I don't disagree with what Mr. Gumpert has said on the law, and we, in our filing, thought we were following our duty of setting out the state of the law as it was and to be applied. But we agree with the partially dissenting opinion and took the position as we did because of the circumstances between the judges. The prosecution can withdraw on their own motion before a trial starts, and that's a common enough principle throughout the world. If a prosecutor is in the position of Regulation 60, but does not carry out his duty according to the regulation, we remind the court what His Honour Judge Chili Eboe Osuji said. If it should not be right for a criminal court to compel a prosecutor to proceed to trial with a case admitted is insufficiently supported in the evidence currently or prospectively available, and clearly wrong for a prosecutor to decide to proceed to trial with a case similarly deficient. And that's why we took issue with the interpretation of Regulation 60 this afternoon by Mr. Gumpert, because it is our submission he is there in Regulation 60 land. When this filing came out, we had drafted a reply detailing these issues, but mindful of the admonition to the parties to seek leave to reply first, we found we'd run out of time by Monday to effectively put anything in to the court. But our submission was on Regulation 60 and the impact that that would have on the present state of the proceedings. So our submission is that in the failure of the proper exercise of the discretion, the court may then move to terminate. And that's how proceedings become terminated. When the prosecutor withdraws charges, the court then terminates those proceedings. And we submit that the structure of this court, with the confirmation of charges being the basis of the case, with the facts underlying the confirmation of charges, which have been precisely identified by the pre-trial chamber and is the basis for the proceedings to continue, as also expressed in the document containing charges, that in those circumstances, verdicts of not guilty can be entered, because the charges for confirmation, which have been proceeded to trial, have been found to be wanting at the point of trial, and an accused coming that far through the proceedings, we are on the eve of trial, well, I think the day after now, or a couple of days after, we would be entitled to verdicts of not guilty being entered. That is fair. It should not be the case that a stigma in relation to reputation is allowed to remain in circumstances where a case fails. That is not fair justice. So that is the structure that we see, Your Honours, and I hope that's helpful. If I can deal with any other matters, please ask.
Thank you very much. I think you are clear enough. But do you still want to make submission in writing?
I've made them now.
Okay, thank you very much. Mr. Gaynor. Oh, sorry. Mr. Gaynor.
Thank you, Madam President. I'll deal first of all essentially with the submissions of Mr. Gumpert on this question. I think it's fairly clear from paragraphs 30 to 32 of the separate opinion of Judge Eboy Osuji, and it's fairly clear from paragraphs 1 to 5 of Your Honour Judge Ozaki's separate opinion that the majority at the time of the Muthaura withdrawal did take the view that the prosecution must be granted permission to withdraw charges. It cannot withdraw charges unilaterally. That was fairly clear, I think, on any reasonable reading of the decision and of the separate opinions. The prosecutor did not seek a consideration of that decision. The prosecutor did not seek appeal of that decision. To a certain extent, the victims have been relying on that interpretation as being the correct one. And to some extent, I would argue the prosecution is now stopped from relying on an alternative interpretation as it waived its right to seek reconsideration or appeal. Second part is, let's imagine, for the sake of argument, that the prosecutor were to withdraw charges for reasons which are wholly unreasonable. Now, ordinarily, in a domestic jurisdiction, you might be able to see judicial review of this. And I'd like to refer to the filings that we made in this case. I'll slow down a little bit. On the 13th of January 2014, in filing 879, at paragraphs 43 to 50, we set out a brief review about the position which obtains in a number of jurisdictions around the world, where either the prosecutor files a notice of nolle prosequi, or simply the prosecutor decides they want to withdraw charges. And very much the international view appears to be that there is judicial control. Whether you're in a civil law environment or a common law environment, certainly the tide is going very much in the direction that the judges can control that process. And in Kenya, it's a constitutional right, in fact, that the court must approve withdrawal of charges. Now, I'll move on from that point. I would like to, for that reason, on behalf of the victims, I would submit that termination of the charges in this case and withdrawal of the charges is in fact the same thing, because the prosecutor cannot withdraw the charges unilaterally. The prosecution must seek the permission of the chamber to do so. I would like to state briefly just a couple of submissions about what Mr. Kay said earlier on. These will just take 1 or 2 minutes. They won't be very long.
Well, before that, if prosecution has anything to say on those two specific questions, I would rather give the prosecution the floor.
Madam President, I rose because I was conscious that the argument Mr. Kay had advanced about, if I can use the term, double jeopardy, about the fairness of there being a not guilty verdict, was a matter on which there could be quite extensive debate. But I doubt whether it will be useful for that to be ex improviso debate, given this is a matter, I mean, absolutely no criticism, raised by the bench in the course of the afternoon of these proceedings. What I was going to say was that given Mr. Kay has raised those potentially important matters, that I would seek the court's leave to make submissions on precisely that question in writing. They would be considered submissions. We could produce them in short order so that there would be no delay. And it would not extend this hearing with perhaps what might be half-considered submissions, which would help the bench less. So my application, and the reason I rose, the reason I rise now, was for leave to submit to the court briefly in writing on the question of whether or not there should be verdicts entered following any withdrawal of this matter by the prosecution.
Thank you very much. So bench will invite you to file written submission on this specific issue.
I'm very grateful.
And of course, after that, defense will respond,
I
and legal representative as well.
I imagine.
When can you submit this written filing?
We're on Wednesday, aren't we? Can I ask for Monday evening? I'm not sure what the date of that will be.
Okay.
We're on the 5th today. The evening of the 10th.
Sorry, could you repeat?
Yes, I was simply calculating on my fingers what date Monday would be, and I reckon it's the 10th, but I stand ready to be corrected. By the close of business on Monday the 10th.
Yes, Monday is the 10th.
Yes, well, that's the time I would ask.
And defense, do you think you can respond to this filing by the end of next week? Or is it too early? You have to see the content before.
And I am sitting as a judge next week, so my diary is out of my control. So I'd be grateful if we could be given 7 days so that I've then got the weekend to look at it.
So 7 days after the submission of prosecution?
Yes. If we can come back to you if it's too difficult a research task.
Okay. And Mr. Gaynor,
Thank you.
7 days is fine with
That's
you?
fine by me. Thank you, Madam President.
Thank you very much.
Sorry to be a pain. That's both parties 7 days from the submission of our filing, or is it consecutive 7 days, 7 days, and 7 days?
I'm a bit confused.
I'm sorry.
You file your submission
on
Monday.
Yes.
After 7 days.
Which will be the next Monday.
Yes.
Yeah. What, both the defence and the victims?
Legal representatives.
I'm grateful.
And now I think we need to come back to you, Mr. Gaynor.
Thank you, Madam President. I had a few points in response to submissions made by Mr. Kay this afternoon. Mr. Kay referred a couple of times to the fact that he was employing, essentially, he was making whatever applications he had to in defence of his client. And that's perfectly fine. There's no contest about that whatsoever. And he has nothing to do with the government of Kenya. And essentially, I don't want to paraphrase what he submitted, but there is a Chinese wall between his defence team and the government of Kenya. And that's fine. Now, nobody is making any suggestions that Mr. Kay has obstructed the process of the emergence of truth at the ICC or in Kenya. But Your Honours are not concerned with the actions of Mr. Kay. Your Honours are concerned with the actions of Mr. Kenyatta. For that reason, justice in this case requires that you look very, very carefully at the actions and positions taken by Mr. Kenyatta throughout 2013 and previously when he was Deputy Prime Minister and Minister of Finance in the Kibaki administration, and particularly have a look at the policy of obstruction employed by the government in respect of cooperation to this court, the policy of obstruction of the emergence of truth in Kenya itself, the speeches which he made to the AU, for example, and the speech that he made on Heroes Day, and his high-level diplomatic campaign. It's up to Your Honours to take all of that into account. Now, whatever unilateral moves Mr. Kay might have made to secure access to mobile phone data are fine, but the fact remains that there was massive obstruction to this vitally important category of evidence by Kenyan mobile telephone companies, and in my submission it is inconceivable that that would have happened simply by the volition of those phone companies themselves. Now, Mr. Kay has pointed out that we should not continue the proceedings on false evidence. In that, I think we can all agree. Nobody wants this trial to begin, or certainly nobody wants a conviction to be entered on false evidence. And he's referred to, he said that my submissions have nothing to do with the evidence in this case. Well, that goes to the heart of the matter. What is the evidence in this case? Is it that very, very small riddled with difficulty body of evidence which was presented to the pre-trial chamber for confirmation? Or is it all of the evidence which is necessary to uncover the truth and access to which is under the direct control of the government of Kenya, which is under the direct control of the accused in this case? Now, if we were in a situation where the accused is the President of Kenya and the government of Kenya were providing 100% cooperation to this court, I believe there would be a great deal of weight in the submissions made by Mr. Kay. If we were in a position where the accused was a very low-level figure with absolutely no influence whatsoever over the government of Kenya, and there were obstruction by the government of Kenya, again, Mr. Kay's submissions would carry a great deal of persuasive weight. But that's not the situation we're in. We're in a situation where there is massive and systematic obstruction of access to evidence by the government, and the accused is in complete control of that government. That's why this case is so unique, and that's why Your Honours have to approach it in a totally exceptional fashion to consider what exactly does justice require in such a situation, given the carefully calibrated model of state cooperation set out in Part 9 of the statute, and given the accused's de jure and de facto control, total control, over the government of Kenya. And I would respectfully suggest that in Judge Ebui Suji's separate opinion, which was just briefly alluded to by Mr. Kay, he referred to the expression evidence which is, quote, currently or prospectively available. Now, his Honour did not fully explain what he meant by the expression or prospectively, but I believe that test is driving at the point that where there is evidence that the court has not been allowed to see, where it has been deliberately withheld from Your Honours in total violation of Part 9 of the statute, that is evidence which is prospectively available to Your Honours. For the same reason, the interpretation of the relevant part of Regulation 60 of the regulations of the Office of the Prosecutor refers to the expression, the evidence available. And I would support the submissions made by Mr. Gumpert on this question. The evidence available in the unique circumstances of this case includes the evidence that the government of Kenya, under the direct control of this accused, has deliberately obstructed access to the prosecution and ultimately access to Your Honours. Thank you, Madam President, Your Honour.
Thank you, Mr. Gaynor. Ms. Higgins?
Your Honour, may I just briefly address you? It touches upon 2 points that have been raised, and I won't take more than 5 to 7 minutes of your time.
5 minutes, please.
Thank you. In my submission, this is important. Mr. Gaynor has referred to what is the evidence in this case. My learned friend, Mr. Gumpert, has contested my learned friend, Mr. Kay's submission that it's the evidence of number 12 alone that relates to financial corroboration or relevant to the corroboration issue, and that there are indeed other witnesses. And Your Honour yourself asked Mr. Gumpert the question of whether obtaining financial information about the movement of funds would be enough to sustain the charges, given the absence of 11 and 12. And I would ask this bench, particularly given its new brother member, to just pause for a moment and go back and consider the meetings on which this case was confirmed and whether there are particulars of financials there. What is the state of what remains when you take away 4, 11 and 12? Are the stones that the prosecution have sought to overturn reverted mainly to pebbles or, in our submission, sand? And, Your Honour, perhaps by way of 1 or 2 examples, I direct you to the pre-trial brief, paragraph 30.
Ms. Higgins, I
Yes.
think it's enough. I mean, I don't want to go into the detailed discussion about evidence in this status conference. You will have enough chance later to discuss those issues.
Thank you for your observations, Your Honour.
Thank you very much. If there is no other submissions, as for the status conference on non-cooperation or cooperation issue, we will make a formal announcement after we consult with parties and participants, including government of Kenya. So you will be notified about the time and the venue in due course. And this brings us to the end of this status conference. I'd like to thank the parties and participants, as well as interpreters, court reporters, and other courtroom staff for their assistance. This hearing is adjourned.
All rise. We will obey.